And there's really not a much council. Yeah, like
LSS? All right, take a seat, please. All right, everyone, let's get started. So there's quite a number of you here. Actually, I'm pretty surprised, to be honest, for LSS, because I know the actual criminal law, like faculty round ones haven't started yet. So yeah, I'm always pretty surprised to see this good number, good turnout over here. Anyway, we'll just do a quick introduction. My name is Sebastian, and I'm currently a year 3 student actually, but more about me later. What we're going to do is we're going to start off with some housekeeping and just some general ideas about what exactly you guys are here for and what we're going to do over the next 12 weeks. So, yeah. So first of all, just some of my assumptions about all of you here. So we are here for criminal law 1. If you're not here for criminal law 1, maybe you're at the wrong place. You have not started criminal law classes with the faculty, but you probably want a head start, or you're really excited. You're like asking, okay, what exactly is criminal law? Like, what's happening? Like, I want to do this reading about R and Brown, and like, what should I do? Should I get the WW textbook, the blue color textbook? What should I read exactly? Like, you're so excited, maybe, or maybe you're just here for the grades. You're just looking for HD, and you don't care for anything else. I don't know. Now, it may or may not be one of your interest areas or potential practice. Hey guys, take a seat, please. But you know, crimes happen every single day, so it would be good to know about crimes anyway. Also, because I think this is one of the fundamental units you have to do criminal law to do any other units. So it's pretty much quite similar to in terms of exam techniques in the future. So this would be a good idea to study criminal law as well. You may watch some TV shows, I don't know, Netflix or something. I don't personally. I know most of you here have went for the, was it the LSS tutoring night? And basically, you guys watch, what movie did you guys watch? I don't know, no idea. But there was a, hey? Yeah. Yeah, that was the movie, Legally Blonde. Yes, that's right. So there are a lot of movies about that as well. So now, a little bit about me as well. So, personally, I've been involved in quite a bit of lawsuits recently. Unfortunately, got a parking ticket that I have to appeal about. Yeah, I was involved in some random witness of like some fights recently, and so I had to go down and file a police report and carry out police. A lot of things, basically. We'll talk about that in a bit's time. Basically, someone was fighting in a club, and just nice I was there, and I observed it, and they apparently called me down for a police report. But anyway, regarding the assignment as well, 20% of it goes to, was it oral plea or something that you guys have to do a prosecution defense later on? So 20% of it goes to something like this as well. Maybe not a police report, but like maybe defending myself against my charges, possibly. Also, I don't know if you guys see this before, but yeah, if this is when you want to sue someone, you use this file. Okay, like you just file this up. Hey guys, for criminal law. Yeah. Perfect. Yeah. So if you guys see this one over here, also, I realize I've not been recording the screen on Zoom. All right. There's Alice over here. Yeah, Alice. I realize I've not been recording the Zoom over here. So let me do that as well. Oh yeah, for the past 5 minutes. If you're watching this recording for the past 5 minutes, I've not been syncing the Zoom and my own laptop and the class that's running in person. So we're thinking now, okay, yeah, here we go. Slideshow. Yeah, so basically, car accidents and you have to sue someone. That's what happens. You file that. So yeah, I've been involved in quite a bit of lawsuits, which is not something that's good, but because I'm a law student, I had to deal with a lot of things myself, because unfortunately the police can't do much. I'm a third year law student, hopefully someone you can trust. I've been teaching criminal law for the past year as well. I met quite a fair bit of amazing people with pretty much same age. I hope not really, I'm 21 this year. But anyway, so yeah, and my students love me so much, they printed me a t-shirt over there that shows my face, and on the t-shirt that says most wanted criminal, and then on the second line it says law tutor. I can bring the shirt someday. But basically, yeah, so I hope you guys can trust me as an interesting person. But if you find me having too much jokes, I can also prove you with my results, which not a lot of people do. 88 went with a 4.0 GPA over here. So yeah, I know what's the technique to doing the best scores. Okay. What's the last one? Oh yeah. Finally, I don't really have passion. My only passion is filming and bringing camera around. So yeah, I do have my own YouTube channel where I make stuff about Monash. Basically, you see a lot of vlogs about Monash. So that's pretty much my only passion right now. I don't think I have too much else. I'm a pretty boring person, to be honest. But anyway, yeah, if any of you is interested in coming and film with me, please shoot me an email as well. Okay, that's probably out of the story. Let's go on. All right, now let's talk about some housekeeping. Classes wise, we're running every Tuesday, 2 to 3 p.m. over here at this exact same venue every Tuesday, 2 to 3 p.m. This will not show up on your Allocate Plus or anything because it's not a faculty run event. It's a LSS run event, so you have to remember it in your brain or maybe a notepad. I don't know where you remember it. But anyway, it's good because we managed to book the same venue. Last year was an absolute nightmare. Every single week we have to check the Facebook group. So yeah, we're in the same venue. You can email me as well. My email is up there, law1114tutor@monashlss.com. If you're watching this recording or if you forgot about this email, I'll post it on the Facebook group, but also at the same time, you can come back to these slides and watch as well. And yes, if you are not part of this Facebook group, please join the Facebook group because that's the only source of communication I will be posting there. If you want to hear me, then you have to join it. If you don't want to hear it, still have to join because you need to know about the classes. Okay. Anyway, so let's talk about some of the top tips to storing HD in Cream because from a student perspective, I mean, I don't know if you guys are really passionate about Cream or you guys are just here for the grades. I'm probably more for the grades, but anyway, that's a very important question over here. So what do I boil down to like some of the top tips that I have? So first of all, it's the content mastery, right? Like if you don't know your stuff, you don't know what assault is, you don't know what sexual offenses are, you don't know what murder is, then why are you sitting a criminal exam in the first place? Right. So first of all, you need to go and understand the different offenses. Also, this year, I believe there are 2 multiple choice questions that's been introduced into your syllabus that was not previously introduced, I believe. And I've not gotten any idea from the faculty yet, but based on my experience with the other law units and stuff, this is likely going to be a content multiple choice question. Same from Foundations of Law as well, where you get this ridiculous multiple choice question for 60 questions in 15 minutes. I don't know how you even do that. But anyway, yeah, you're going to get content. Okay, so content-wise, you need to go and study. Second of all is this is pretty lame to be honest. Determination. You need to keep up to date with your assignments and exams also. Please don't leave it to the last minute. I remember back then when I was in year 1, I had quite a fair bit of friends who just don't know when the assignments are, just let it slip over. Anyway, third of all, application-wise, I think this is the most important part of the exam because in your exam, you are getting tested based on MCQ questions, your oral plea, as well as your problem questions. That means if you know what the facts of R and Brown is, you're not likely going to get marks, but you only get marks if you can apply the case law to the facts. So, and fourth of all is just to repeat for all these weeks, which is a ridiculous amount of time. But anyway, we're going to talk about the lesson outline for today as well. Ooh, all right. Yes, also one thing about material-wise, don't worry too much because I know you guys have not yet started. What this lesson is meant to be is just to prepare for everyone over here in case you want to do some head start, in case you want to do readings from your textbook. That is the breakdown. What I follow for my lesson outline is exactly the same as your reading guides. So for example, if you see under section 1.1 or 1.2, you will see this heading of what is a crime, or you will see this heading of freedom, morality, and the criminal law. So because I don't have any idea how the faculty is going to run, to be honest, so the best bet for me is just to follow on the reading guide. And then later on, when it comes to practice questions, I hope you guys have that as well from the LSS, and also we are going to discuss practice questions. Later on in many other years, I heard many other tutors, they really spend quite a number of time on the content-wise, but I personally like practice questions a lot, so do come prepared as well for that. All right, so we're going to ask ourselves the first question. It's really annoying. Oh, I actually bring this keyboard over. Why am I keep moving? All right. Anyway, oh, that's so much better. All right, first question, what is criminal law? Anyone? I mean, what is your idea of criminal law? Big question, yeah. No one. Yeah, go and tell us your name as well.
Hi, I'm Caspian.
Yeah, Catherine.
Technically first year law student, but I'm not first year finance student, so I would say criminal law refers to the body of law pertaining to not governing, classifying, governing, and giving you options for when people violate the law.
Yeah, okay. So it's like
Pretty
a
vague, but
series of principles and stuff. Yeah,
principles and outlines, right?
principles and
And,
outlines.
and guidelines with the correct terminology, something else.
Yeah, is that from textbook or something?
No, I'm just, I studied criminology for a couple of years, so I'm just trying to think back to when we tried to do mix two together.
Yeah, okay, that's a pretty good idea. Okay, thank you. So what we're going to do is actually there's quite a fair bit of contention in terms of how criminal law is being defined. Later on, when you do public law and statutory interpretation as well, there will be different perceptions, idea about what is law as well. So we're just going to look at some of these common definitions. So first of all, like we could ask ourselves some questions like, what constitutes criminal conduct? Probably this is quite similar to criminology. Say, for example, are crimes always actions, or an omission can be criminal as well? Say, for example, okay, say, for example, right before this class, I was told that there is likely going to be a robbery that's happening at 2:30 p.m. I don't know why the robber decides to tell me that, but let's say the robber tells me that there is going to be a robbery at 2:30 p.m. And I didn't make any announcements of that at all. And I just kept teaching the class. And at 2:30, this robbery came in and maybe stole that MacBook and the headphone away. All right, I don't know how much that costs, $3,000, $2,000, let's say. All right. And then maybe the robbery also shoot you, boom. All right, and I didn't do anything. It was an omission of me. Okay, can I be charged for criminal conduct? That's one question. So later on, when we look at, say, things like negligent manslaughter by act and omission, that could potentially be an area of contention. Next question, do crimes always have to be intentional, or can they be reckless or negligent? Right. So, for example, if I say I got the parking ticket or driving offense or whatever, probably don't learn from me. But yeah, say for example, I didn't see the red light for whatever nonsense reasons, and then I just drove past the red light. I didn't intend to run the red light, but can I be charged? Yes, I can. So there are offenses for recklessness and negligence as well. In actual fact, when you talk about beating a red light, that is what we call an absolute offense. If you get caught by the camera, you're charged unless you can prove otherwise. Are crimes always immoral? Right. So for example, if you do some things that are moral, but can you be charged for a crime as well? Does crime affect the individual or public? That's also one of the questions. And consider some of the drug offenses as well. Okay, euthanasia is one of the biggest things as well, right? Are they immoral? Not really, right? But why are some countries treating them as a criminal conduct. Next, so I'm going to skip this. So now we're going to look at the definition of a crime. So first of all, we start off with the very layman, non-student, non-law student kind of definition. This is when you do a Google or you do a ChatGPT. What do they tell us? System of law concerned with punishment of offense. Seems like we're missing something over here. Yeah, that body of law sentence sounds very similar to ChatGPT for some reason. Basically talks about rules and regulations that define criminal offenses and procedures. Procedures is something that you're going to learn in Crim 2. I'm doing Crim 2 right now, so it helps me to revise too. And then it tells us about some of the conducts. If you read that, it says criminal law typically involves conduct that is considered harmful. So sometimes you may have conduct that is not being harmful. Okay, I think if I continue to use Google and ChatGPT, I think you guys will leave. So let me give you something that's more academic over here. So what do we have? We put some pictures. Does it look academic? Not really. Okay, never mind. So what do we have? Let's look at some of the textbook definition. So one of the approaches we have over here is what we call a positivist approach. Positivist approach, or what we call legal positivism, is basically when you have a law that is only concerned about what is in the law. So for example, if I say you can't breathe in this class, and I somehow codify that, and if you breathe in this class, you have breached the law. That's what legal positivism is about. So basically, a positive approach tells us that a crime is a legal wrong that can be followed by criminal procedures, which may result in punishment. And you see, that literally tells us just by procedures. I don't care about morality, I only care about procedure. That's something that's very important because I honestly have no idea what your exam is going to be, to be honest, but also don't ask me for help or assignment. But anyway, I will try to help you guess what's going to come out for MCQ. And I think one of the things that you really want to know, and that's what I see from the reading guide, is you need to understand the difference between morality, criminal law based on morality, and criminal law based on positivist approach, i.e. purely procedural criminal law. So William's positivist approach does not reside in the wrongful act itself, right? So I don't care whether something is wrong or not, but in the legal consequences that follow. So as long as there's some sort of a legislation and you breach that legislation, then you will have conducted a crime. We also consider a few other ideas, okay? We also consider a few other ideas where crimes are distinct from other legal wrongs. If you look at the syllabus or maybe a course progression map, you will see that there will be things like tort law, contract law, property law, admin law, litigation, dispute resolution, trust, a series of things. And then you see criminal law as the first thing. So from the next law, but I think it's yes, I listen to Japanese music. Anyway, it's nice background music though. Yeah, so conduct should only be criminal if it possesses the necessary elements of publicness, moral wrong, and that crime will result in significant punishment. You see, the idea of moral wrongdoing is sometimes can be quite contentious. And in your reading guide, you will see this debate. I believe in your reading guide, there will also be this YouTube video to watch where I think it's the HLA part and the law definitely debate was 36 minutes, pretty long. Where you think about this idea of whether morality should be involved, right? And then this could be distinguished from civil wrong because civil wrong is between individuals. For example, recently, or very soon, I'm going to sue someone for the first time in my life, which is pretty scary. I have to sue them because they crashed my car and they want to pay. The police is not going to do anything about it. I have to sue them, right? Another thing is that it don't just usually affect life, liberty, property. but rather just financial consequences, right? For example, silver wrong, say someone hit my car, I'm suing them not because they threatened my life, just because I was which I'm pretty sad. But anyway, you also have civil wrongs, which usually result in financial remedy. So for example, if I sue some other party, then they're going to pay me in terms of money. But if you breach the criminal law, you're probably going to put in prison or some other things that affects not just financially, but liberty, also maybe your reputation. All right, so I believe in the LSS sketch notes, we've got this summary diagram over here. So one of the possible MCQ questions that you guys can prepare would be maybe which of the following is a difference, is false about the difference between crimes and civil wrong. And then they're going to put 3 of these as a correct. And then maybe the last one they might swap around, they might say crimes, the standard of proof is on the balance of probabilities, and civil wrong, balance of the standard of proof is beyond reasonable doubt, and you choose out the last one as the option. That might be a possible question. Same thing for your preparation as foundations of law. There's going to be 60 questions, but no one knows exactly what the questions are. There is literally 0 practice questions, unfortunately. I think the same for criminal law applies. So what you have to do is you have to actively craft the questions yourself and think about how this might be tested in terms of a criminal law exam. And that's I think the secret towards Scholar HD. That's what I call active learning, right? Looking at the content and thinking about possible questions. Because I see a lot of people at law school, what they do is, not saying rigorously typing down notes is bad, but that's the only thing they do and they think is very productive. It is something that's important, fundamental. You have to have notes, but beyond that, you also have to think about possible questions that will come up and how you want to apply them. Right. Okay, so next idea we're going to look at that. I believe this is under reading guide 1.2 or 1.3, I can't really remember. We're just going topics by topics, and when you go back from this session, I want you to start reading through these topics and actually crafting your own notes and also thinking about how you're going to apply them in the exam. Now, so we're looking at personal freedom, morality, and the criminal law. This is when we look at 2 important concepts. First concept is R and Brown, or the Crown and Brown, the case the case where you're going to have extensive discussion in your first criminal law class. I remember in my first criminal law class, I read a whole series of nonsense, and then the tutor spent like 1.5 hours out of a 2-hour class on R and Brown. I was like, what on earth is going on? So yeah, we're going to unpack this case a little bit, and then once you go back, you can go and read the full case. It's, I think, 53 pages. Goodness, a lot of reading. Yeah, but we're just going to summarize that for you. And the second thing we're looking at is we're looking at the 3 legal philosophies. So HLA Hart, Lord Devlin, and suddenly I forgot the last person. We will look at that in a bit time. HLA Hart, Lord Devlin, and what was the last person? John Stuart Mill, yeah. All right. So let's look at this first. So why do societies use the criminal law? Why can't they just leave the citizens to sue citizens? Why do they have like a third party involved? The underlying reason behind this is because the criminal law is an instrument of social control or repression. The reason why you don't just stand up halfway through this class and shoot me is because there is a criminal law underguiding this entire society. There are certain conducts that's being acceptable and certain conducts that's being criminally punished. The reason why you don't just maybe secretly take your friend's $500 in his or her wallet and walk away, because that will constitute theft and you're going to get like a lot of punishments for that. So the criminal law aims to regulate behavior from both past and future orientation. The law reacts to harmful behavior that have occurred, i.e., for example, if you stole $500 from a friend today, you are going to get punished, but also seeks to educate and modify future behavior to prevent harm, i.e., if your friend stole $500 from today, then maybe in 1 year down the road, when you heard about the consequences of your friend, you are less likely to behave such way and steal your friend's $500. So the repercussions are probably more effective than the positive incentive to obey the law. But some argue that criminal law is an enforced morality, i.e. use the criminal law to enforce certain sets of moral values. So this leads us very nicely into consideration of this question. What role should the criminal law play? Right? Should they only target individuals that harm others, i.e. we're looking at the harm principle? Or can they also use to enforce morality that is common to the society? If so, whose morality should it be? So we're going to start by looking at this question. Can I just get a show of hands? Who here is familiar with the case of Aaron Brown? One.
I studied
Criminology. Anyone else? Two? Yeah. So most of you are not really familiar. No worries. So what I'm going to do is I'm going to take the next 2 minutes, just get you guys to read through the summarized facts, and then we'll talk about this case.
basically they wanted to charge for sodomy initially, but then sodomy, it was already back then, it's very archaic, it's look at our parents. Basically, no one ever made it through. Drugs might have been used, but they didn't have any proof of that. And legally, that means something else. Everyone was over 18. Everyone in the recording at the time of recording was over 18. Some people were older than that. People are weird and like people are weird and they're fucking weird basically. And I didn't know which one that was. It's very similar to the Uniqlo horse. Do you know about Mr. Hands, that case? Yeah, it's similar to that, but it involved less animals.
All right. Are we ready? Some discussions going on. So I will simply put this case into one sentence. Okay. You and your friends have some weird hobbies. So you and your friends want to do some stupid things in your own private nature. In a safe way, you have consent and it's for private use and there's recordings for some reasons, just like the LSS. But, for whatever reason, the Crown wants to prosecute, I almost said prostitute, prosecute you for criminal offenses because consent was not a defense to this kind of sexual conduct, and an appeal was launched as a result. So I think back then, from what I can remember, there was like 20 minutes used to discuss the facts and stuff. Like understanding this case is quite important because it's one of the most important cases. In law, you're going to see a lot of cases. Okay, you're going to see like every sentence they're going to put a bracket. And you read the next sentence, the bracket, and then footnote and stuff, and like you feel like, wow, there's so many footnotes and stuff. But this is literally the important. Like if I have to choose a case, this one, and then the rest you can just look at it, like briefly skim through and stuff. So let's look at the appeal. Sorry, before that issues. Who here is familiar with the idea of IRAC? IRAC. IRAC. No one. Oh, just you. All right. Where did you hear it from? One of the readings. All right, good. They don't teach in foundations of law. No.
We are in week 2.
Yeah, in the textbook, some page 50 something, I still remember for some reason. So let me just write this down. Basically for the recording people, just IREG. I might just leave a note in the Facebook group later. But anyway, I'm going to write this down. IREG. In every law question basically you're going to have this idea where you're going to discuss the issue first, and then you're going to look at the rule. You're going to look at application. You're going to look at the conclusion. So basically this is used both for your problem questions, which you're going to use for the next 4 years or 5 years or 6 years or 7 years. I don't know how long you're going to be in law school for. But anyway, that's the first thing, issue. And then you're going to tell us, okay, what exactly is the issue? Over here, the issue would be, can consent be a defense to this kind of sexual conduct? Right, the torturing of genitals, I think. So that's the issue. And then you're going to look at the rule. What does the law say? Most of the time, you're going to look at what we call the statute. Right? So there's legislation that legislate what the rule is. Sometimes the rule comes from case law, where you have all these brackets stuff. So not those brackets, but case law brackets. And then you're going to have application. Based on the thinking of a reasonable person, do you think that the law has been breached? And you conclude, okay, is the defendant guilty or not guilty of that offense? All right, so here the issue, or rather the issue is whether defense consent. Okay, consent can be defense. And then the rule is set out in Offences Against the Person Act 1861. It's UK law. Okay. Now, so the question over here is where a wound or assault occurring him actually body harm in the course of a sadomasochistic, yeah, I cannot pronounce it, encounter. Does the prosecution have to prove lack of consent on the part before they can establish a guilt under Section 20 and Section 47? That's the issue, right? So let's look at what happens in the majority judgment. Okay. Goodness, reading this case was a nightmare. But anyway, so here's the majority judgment. The majority judgment says that the society is entitled and bound to protect itself against a count of violence. It seems that there is some sort of morality coming in. So like, even if you consent to violence, society is against it, right? That's what law temperament says. Another one is the possibility of corruption of young men is a real danger. Okay, so maybe they might have equated the actions to corruption. That again is perhaps morality coming in. And the sadomasochistic homosexual activity cannot be regarded as conducive to the enhancement or enjoyment of family life or conducive to the welfare of society. Right? So we're looking at a lot on morality over here. One other thing before I forget is it's quite important for you to look at the judge's comments individually and think about what the similarity and the difference in the judgments are. Because one thing is it's good for understanding, but also because in the multiple choice questions, if they have 4 judgments and 4 judges, if you like, which judge is part of the majority, which judge is part of the minority, that could be a question as well. I have no idea, but yeah, just thinking about that. So now let's look at the minority judgment. So I think the debate over here is about really enforcement of certain sort of morality within our society, and also the rights of an individual. You have the freedom to do certain things. Say, for example, right after this, maybe one of you is my friend and say, let's go and grab lunch after this. And then the society says, maybe the law says, no, you can't do that because maybe I'm a student tutor and I can't grab lunch with one of my students. That'd be weird. Right, so there's some sort of rights of an individual. But then the question becomes, to what extent can that line cross, right? What happens if maybe one of you went on to do some torturing when we went to do some torture, then do I have the right to do that, for example? So in the minority judgment, it was held, right, that the state should interfere with the right of individual to live his or her life as he or she may choose, no more that is necessary to ensure a proper balance between special interests of the individuals and the general interests of the individuals who together compromise the populace at large. So what it is trying to say over here is that we need to find a balance, right? There are people with special interest, i.e. weird things, they do weird things, but also we also need to think about what is necessary, right? And what are the rights of an individual and come to a balance. And it was also held that it is a matter of policy for the legislature to decide. If the society takes the view that this kind of behavior, even if it's done in private, is either so new or so extensive or so undesirable that it should be brought down for the first time within the criminal law, then it is for the legislature to decide. And this crosses the idea of this thing called between the legislature and the judiciary, right? Should the judiciary decide the law or should the legislature decide the law? If the legislature didn't criminalize it, why should the judiciary make the law? Are judges making laws? That's also a question that you will be learning in public law and statutory interpretation as well. So pretty much 5 judges. And so in the end, we have a 3-2 split when it comes to the decision on this appeal. So the majority held that consent cannot be used as a defense to actual bodily harm. So public policy requires this immoral conduct to be criminalized, punished as crime as pleasure derived from the infliction of pain is an evil thing. But the minority judgment summarized there is no harm to the public when consensual activities are done in private. There is no public benefit or reason to criminalize it. All right, I'm just going to give everyone 1 minute to digest. If you want to take down some notes or whatever, that's a summary of this case. 53-page case boils down to this idea. All right, I'll wait for a minute or so.
Like which sentence is that? Which is just the second point. Logical right. But even it's too, but like, at least that's what even if the philosophy was consistent, it's enforcement it never is. We just will always get. But no, I like starting to. No, these 2 keys are broken. Unfortunately, when it comes to law courses, this is the 2 most common. So C's will often like W key falls off regularly. Yeah. If they did steal my laptop, it wouldn't be like if they had to get rid of it first. Like it would cost them first to get it to All right. I hope that's enough time for all of you. I saw the phones out. I will do that as well. Don't worry about it. But anyway, so that's basically how you unpack a case. At least that's what I would do it. I think it's rather evil. I think it's the pleasure derived from the infliction of pain is an evil thing. I think it's an evil thing to do if I just get you guys to read 53 pages of cases. So luckily you are here. So now you can go and read the 53 pages after this session. Okay, so I hope you guys digest it a little bit. One other tip from me is that sometimes, at least in my first year of law school, I felt the urge that I had to read every single case, and honestly, it was too much. So later on, I found that what could help me simplify this task is to really
summarize, okay, look at what this law is actually about. Look at the ruling, look at like one sentence summary or one page summary and understand the case first. And you have this big picture and you go back to read the case. I think it might help a lot, especially to speed up. And also note one more thing, you're going to get like 10, 20 cases to read every single week. You're not going to finish them. So really choose which case you want to read and choose the one step. Maybe not that important. Now, the faculty might kill me for saying this, but anyway. Now, so let's look at, oh, it's the same thing. Why do you have same thing twice? Goodness. Okay, now let's look at some of these legal philosophies. So in your reading guide, there is going to be 3 legal philosophies, J.S. Mill, H.L.A. Hart, and Lord Devlin. So we're going to look at the perception of criminal law by all 3 of them. What I'm going to do here is I'm going to give you a summary, and again, it is your job to go back and do the reading guide. I'm just here to make your life a little bit easier. Last few years, this concept here has been pretty, like I wouldn't spend a lot of time to be honest, because it wasn't tested, like it was literally introduction. But I think the faculty revised the syllabus this year and included 2 multiple choice questions. This might just nice be the thing that they're going to test. If I do get something, let's say for example, if they do tell me that the test is about topics 1 to 3 or topics 1 to 4, for example, then I might just introduce a few other practice questions that I could think of, and we can work through them in class. All of them are by me, and just to say. All right. Just a moment. I think I might just use this. It's a bit nicer. All right, so we just want to summarize the perceptions by all 3 of them. So first of all, we have J.S. Mill. J.S. Mill wrote this book on liberty, and basically he's a pro-civil liberties. He prioritized individual autonomy above all else, unless it does harm. So he has this harm principle. As long as you don't harm anyone, I could do anything. I could run a red light at night. What else can I do? What else is very bad? Can't think of anything right now. But as long as I don't, that's fine. Okay. I could do this as well as not punch you because there was no harm. But once I punched you, then there is some sort of harm. So that's J.S. Mill. His book is called On Liberty, just because I think I'm running low on time, so I'm not going to go through everything. But if I can make the slides available, I'll make the slides available. I have to check with the LSS team, to be honest, on that. I don't know. But anyway, let's look at the second person, H.L.A. Hart. Again, he's a liberal person. I think he wrote this book. Let me just check this book. Yeah, he wrote this book called Law, Liberty, and Morality, where he argued that criminal law should be based on the principle of individual liberty as well. So it should be restricted to punishing harmful acts again, right? So what he said was the law should play a minimum role, play no role in interfering private liberties unless vulnerable members of society are at risk of harm, right? So for example, in the case of the Crown and Brown, perhaps H.R.A. will say, no, there's no issues. Same thing for J.S. Mill. He will say, no, there's no issues, right? But finally, when it comes to Lord Devlin, he argues that there should be an active role. The law should reflect common morality of time and used to protect society and preserve order, with an exclamation mark. He must have thought about it. No, I added that, don't worry. What Lord Devlin would do is he probably would think that in the case of R and Brown, yeah, they should criminalize that sexual conduct of torture of genitals and stuff. So conservative, and then we have 2 liberal at the front. All right. Again, I'm going to leave you guys 1 minute to digest these 3, and let's see if there's any questions.
When he says common morality, I'm guessing he's referring to the opinions of the majority
Of society.
Well, but that's like that's quite vague. So I'm guessing based on his age, it's typically just the majority the people in society who are in the majority position are also privileged, right? Oh, that's interesting.
The common majority people who are controlling.
So all white men.
Yeah, all white. Yeah, absolutely.
Oh no. Yeah, because that's always in the film. When all white men. That's always in the film. Maternal honesty. Yeah, like in this summaries, they're meant to be like they're meant to be all.
All right, any questions? No, just now we have one question here and you asked about this idea of common morality. Right, this common morality probably just refers to common morality among people who are in power, right? Not everyone. So, we're really running low on time, so I'm just going to skip the sentencing framework for today. We're going to do practice questions. I have 2 practice questions. Okay, so basically, you know, you have the multiple choice coming up, and I'm the only LSS tutor that provides practice questions for MCQ. Okay, if you look at anything else, you don't. So it's a privilege, I guess. But anyway, just to get you guys thinking, we have 2 questions for today. First of all, which of the following is false about the case of R and Brown? All right, so take a minute or so to think, and we'll go through that. We should have the Kahoot music in the background. This is it is too quiet. Yeah, maybe in the exam you just do 20 of this and you get 20 marks. So easy. All right, who thinks the answer is A? 3-2 split? Yeah? No? Yeah, it's true. So pretty close. If it's today, probably the answer will be a little bit different. Second of all, consecutive abuse as defense, who thinks it's false? No? C? Ratio? C, a lot of C. Okay. D? Oh, everyone is right. So easy. All right. Next question. Which of the following legal philosophies has a conservative idea surrounding the criminal law? J.S. Mill, H.L.A. Hart, or Lord Devlin? Who thinks it's A? J.S. Mill literally wrote a book called On Liberty, yeah? Now, B, H.L.A. Hart. No? Lord Devlin? Everyone. All right, congratulations, that's it. So I believe, one other thing I want to talk about actually. So I've been talking about multiple choice quite a fair bit as well, but also there's another thing that you guys have to do, which is the oral play. Not the oral play in the sense where you make a police report like me, but acting as the actual judge, not the judge, the lawyer, right? I'm just there as a witness. So you're going to, I don't know in whatever weeks, but in somewhere in the semester, you're going to have this thing called the oral play, where you're going to make a 5-minute video, or how many minutes, whatever. When I did it was 5 minutes, okay? And there will be a case, whatever case, some nonsense scenario about maybe assault, battery, these kind of things. And you're going to argue for the judge, argue and make a 5-minute video for that. Now, that's going to be 20% of your exam, at least that's what the website says. So what are some of the resources to consider? So first of all, you need to understand this idea of sentencing framework, which is something that we're going to look at next lesson. You're going to also look at some of the key legislation surrounding this. And in Foundations of Law, you're going to get this research quiz, I believe, where you're going to learn how to search out. But it's pretty simple. Literally just open up Google and type in Crimes Act 1950 and Victoria. And you're going to see this Crimes Act. You just open it up, right? Just scroll through a little bit. Also start looking at the Sentencing Act. There's also this thing called the Sentencing Snapshots. How do I do it, right? Like over the past year when I started tutoring criminal law, I received, even till now, I was receiving a lot of questions from the previous batch of criminal law students, texting me on Instagram. Not that you're encouraged to do that, but anyway, yeah, they're asking me how to do well. So, I would say first of all, prepare early. Like the reason I'm telling you about multiple choice, the reason I'm telling you about this quiz oral play is because I think you should really start early. Not that I could do a lot of times, but that's the ideal scenario. Be sure to check the requirements of the assessments. Like what I said, I have nothing. I literally have no connection with the faculty. I'm just one person by myself running this institute, hoping you guys to improve. So be sure to check the requirements. Conduct the conference with your peer early. I believe one of you will be acting as a prosecution, one of you will be acting as a defense with relation to this oral plea, unless they change the thing. And then final thing is to give reason arguments rather than listing the legislation. So one of the key skills that we learned today is you have to maybe perhaps consider the IRAC framework, issue, rule, application, and conclusion applies to everything basically. All right, so that's pretty much from me today. And any questions before we go? No questions? All right, if not, hope you guys have an amazing afternoon. I will see you guys next week. Bye.
Yeah.